Welcome to Time is Not on Your Side with your host, board-certified litigation attorney Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now here's the host of Time is Not on Your Side, Rob Eckard.
Today's topic, the business divorce, suggestions to prepare for it, and what issues should be considered by both sides. Hello, and welcome to another episode of Time is Not on Your Side, a podcast dedicated to bringing you relevant, practical, and useful information from a perspective based upon decades of experience. I'm Robert Eckard, board-certified business litigation attorney and government investigation specialist with an LLM degree in international law and business. The topics in every podcast are thought through by me based upon the number of cases I have handled on these topics, providing my insight and opinion based upon 25 years of experience, both in business litigation and government investigations, while representing clients in both state and federal courts throughout the United States and internationally. The business divorce, suggestions to prepare for it, and what issues should be considered by both sides. I never want to go through this again. That's a phrase I've often heard people say that are involved in a business partnership breakup and a business divorce, where anxiety, stress, emotions can eclipse even the nastiest of family law divorces. Business divorces can be a knockdown, drag-out event as business partners go through this process. But partners who plan ahead and navigate their business divorce to avoid unnecessary stress and harm to the company and themselves, frustrating their personal business objectives. However, this type of planning requires partners to, one, review and understand the terms of any agreements in place that govern the separation. Two, develop a practical, real-world objective, appraisal of the value of the interest that is being transferred. And three, consider the business issues that may arise for both sides after the business divorce, such as future competition by the departing minority partner. The change in separation involved in a business divorce and separation can be hard on all parties, but anticipating the issues that are likely to arise provides a roadmap that the partners themselves can chart a more predictable course to smooth sailing to the other side of the transaction. So here are some of my suggestions from experience as a board-certified business litigation attorney with more than 25 years experience, who's been involved representing parties on both sides of the process in this business divorce, from the perspective of the majority owner and the minority investor being purchased. Step one, closely review the written agreements that apply to the business divorce. The first step in approaching any business divorce, just like a sport or other competition, is to know the rules of the game. The majority owner. The majority owner needs to understand whether a buy-sell agreement exists that allows the owner to redeem the interest held by the minority investor, or that will permit the investor to demand a buyout. Sometimes a buy-sell provision will be contained in the company's bylaws or operating agreement. If this type of agreement is in place, it governs the manner in which either party can exercise a call or put option that will result in a redemption of the minority interest. In either case, the agreement will address how the value of the minority interest is determined, and it will also set forth the payment terms after the value of the interest is determined. In the absence of a buy-sell agreement, the majority owner does not have the right to trigger a repurchase of the minority interest, and therefore has to negotiate with the investor to find terms that are acceptable. If the investor demands payment of an excessive amount or insists on including unreasonable terms, it's likely that the buyout will not take place in the near term. If this scenario, the majority owner will have to consider taking actions that will cut off further economic benefits to the investor before a liquidity event takes place. This is known as a freeze out or squeeze out situation. The minority investor, shareholder. The minority investor also needs to determine whether a buy-sell agreement exists that permits the majority owner to exercise a call right to redeem the minority interest, or that authorizes the investor to exercise a put right, which requires the majority owner to purchase the investor's interest. The terms of the buy-sell agreement are therefore critical to fully appreciate the business divorce consideration. If no buy-sell agreement is in place, the good news is that the minority owner investor cannot be forced out of the business by the majority owner on terms the investor considers unfavorable. The bad news, however, is that the investor cannot require the majority owner to repurchase the investor's interest for the price desired by the investor if the investor wants to exit the business for any reason. Without a buy-sell agreement, the minority investor must assess whether leverage can be obtained that will bring the majority owner to the table to discuss a buyout. This leverage may be available if the majority owner has engaged in self-dealing in managing the business or some other conflict of interest transaction. The bottom line is that the minority investor needs to evaluate the majority owner's conduct to determine whether any misconduct by the owner will provide some leverage that the investor can apply to facilitate a buyout discussion with the owner. Step 2, develop a real-world practical assessment of value. The next critical step for the partner to prepare for a business divorce is to understand the actual value, fair market value or otherwise, of the minority interest that will be changing hands from the majority owner's perspective. If a buy-sell agreement exists, it will specify the methods the parties must use to determine the value of the minority investor's interest that is being purchased in the business divorce. If no buy-sell agreement exists, the majority owner will need to negotiate the price directly with the minority investor at the outset. The majority owner typically directs the company to retain an independent valuation expert, such as a forensic CPA, that will help determine how the parties can value and negotiate a purchase price. Under these circumstances, however, the majority owner should expect the minority investor to demand payment of a premium for the minority interest because the investor has no contractual duty to sell as long as the minority investor's proposed purchase price is within the realm of reason for the majority owner who wants to purchase the interest, and they should consider paying that premium because, one, the owner will secure the return of the investor's equity in a manner that avoids prolonged exit. Two, the purchase of the investor's interest will avoid incurring legal fees dealing with claims or litigation by the investor. And three, the owner will capture all future appreciation in the value of the business. Now, from the minority interest investor shareholder standpoint, as previously noted, the minority investor cannot renegotiate the purchase price for his or her interest in the company if the buy-sell agreement exists that dictates the process for determining the value of the investor's interest. When there's no buy-sell agreement, the minority investor can choose to hold out and secure a purchase price that reflects the fair market value, the best price the investor can get. As a cautionary note, however, the majority owner has no contractual duty to purchase the investor's interest in the absence of a buy-sell agreement, and therefore, if the investor drives too hard of a bargain, the negotiations may break down. The majority investor or the majority shareholder may walk away and impair the minority's rights to dividends and distributions. As a result, the investor who insists on receiving top dollar for his or her minority share must be prepared to wait a very long time, if ever, to be in a position to monetize their interest if the majority owner is not prepared to buy the shares. Step 3, consider post-separation business issues. The final step in preparing for a business divorce concerns the need to consider what will take place after the business divorce has been completed. From the majority owner standpoint, the planning process needs to address how the company will operate after minority investor departs, which is more of a significant issue if the investor had an active role in the business. If so, the majority owner will need to take steps to arrange for a smooth transition of all duties previously handled by the minority investor, such as handling customers, vendors, and supervision of company employees. The majority owner will also want to ensure that the departing minority investor doesn't create problems for the company when leaving. First, the majority owner will want to retrieve all confidential information that is held by the investor as part of the business closing. Second, the majority owner needs to consider whether to request the minority investor to accept restrictive covenants that prevent the investor from competing with the company or from soliciting employees or businesses that the company's done business with. If the majority owner believes these restrictions on the investor are necessary, the owner will likely have to pay additional consideration to obtain them in addition to the purchase price that's paid to the investor for his interest in the company. The majority owner should require that this additional amount be paid to the minority investor over time so that the unpaid amounts can be withheld if the investor fails to comply with the restrictive covenants during the period they remain in effect. From the minority investor standpoint, the minority investor does not need to retain confidential information that belongs to the company, but the investor does need to decide to what extent he or she has any interest in remaining active in the same industry as the company. If the investor wants to remain active in the industry in some capacity, the investor needs to make sure that complete clarity is reached regarding the exact scope of the restrictive covenants that the owner seeks to impose on the investor's future conduct. The extent of the restrictive covenants will also impact the amount that the minority owner seeks in additional compensation for accepting these new restrictions. However, if the minority investor is receiving a fair price from the majority owner for the purchase of the investor's minority ownership interest in the business, the investor should be wary of overplaying his hand. If the minority investor seeks too much compensation from the majority owner in payment of the restrictive covenants that are requested by the owner, the investor may cause the entire deal to collapse and unable to monetize the minority interest at a reasonable price. In conclusion, note, business divorces include some bumpy roads to cross for the partners, but if they plan ahead, they can successfully make it to the other side of smooth driving. This advanced planning does require the partners to, one, develop a keen understanding of their contract rights based upon the term of the agreements in place. Two, determine the objective fair market value, the minority interest that is being sold to the business divorce. And three, consider the business goals of the other partner after the divorce has been completed. This careful planning by business partners will enable them to navigate their way through business divorce in a manner that saves them time, expense, preserves the relationship, and also avoids running the business into rocky shores. If you encounter any issue in this process that you do not feel comfortable handling alone, you should seek experienced legal counsel, but well thought out advanced planning should be part of your strategy. This concludes another episode of Time is Not on Your Side. Be sure to hit the like button on all social media platforms. Follow us on all major social media platforms such as YouTube, Spotify, Instagram, and drop me a message if you have any questions or comments.
You've been tuning into Time is Not on Your Side with your host, board-certified litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.